आप लोग को मिलिट्री लॉ के बारे में कुछ बताना चाहूँगा। वैसे तो बहुत बातें हैं, लेकिन कम समय में जितना हो सकता है आप लोग को बताने की कोशिश करूँगा। जब हम मिलिट्री लॉ की बात करते हैं, कोई भी लॉ की बात करते हैं, तो सबसे पहले कॉन्स्टिट्यूशन ऑफ इंडिया हमारे दिमाग में आता है, बिकॉज अल्टीमेटली एवरीथिंग वर्क्स अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया। और जब हम मिलिट्री लॉ और आर्मी के या नेवी एयरफोर्स के रूल्स एंड रेगुलेशंस की बात करेंगे, तो आपको सबसे पहले आर्टिकल 33 ऑफ द कॉन्स्टिट्यूशन याद करना पड़ेगा। कई बार आपने देखा होगा, लेकिन आप लोग ने जिस तरीके से आर्टिकल 33 को पढ़ना चाहिए शायद पढ़ा नहीं होगा। Article 33 empowers the Parliament to curtail the fundamental right of certain people who are discharging their duties with the armed forces. And therefore, whenever you talk about rights available to a man in uniform, then Article 33 comes into play, and the rights available to them are curtailed by virtue of laws made by the Parliament in the backdrop of the requirement of Article 33 of the Constitution. That's one thing which I want each one of you to remember. Now, when you talk of military law जो था, जैसे हमारा आर्मी एक्ट है, सन 2011 में ब्रिटिशर्स ने बनाया। और जब ब्रिटिशर्स ने उसको बनाया तो उन्होंने पनिशमेंट, डिसिप्लिन और प्रोसीजर्स ऐसे लेट डाउन किए कि जो भी वो चाहेंगे वही होगा। और एक व्यक्ति हैं जिनका नाम है DM सिन्हा। He was the first Judge Advocate General of the country, and he became the Judge Advocate General when he was working with the British Army. And when India became independent, he was entrusted with the job of amending the military laws, and therefore he is the architect of the Army Act of 1950. And when he was enacting the Army Act, it came to his notice that with the nature of discipline required and the procedures to be followed in the army, there has to be something in the constitution which empowers the parliament to make a law curtailing certain rights. And it was his brainchild that Article 33 of the Constitution came into being. He took an appointment with Dr. Ambedkar, told him about the effects of right to be curtailed, and that is how Article 33 of the Constitution came into being. And I can tell you, he became the first JAG to be appointed as a judge of the High Court, that is Guwahati High Court, and he was a judge of the Guwahati High Court for more than 8 years. So that is the founding father of the military justice system in the country, and he was the first JAG appointed in the time of the Britishers. Now, if you go through the military law consists of 3 acts: Army Act, Navy Act, Air Force Act. Now, as far as the structure of the military is concerned, when we talk of military, all the 3 are part of the military: Army, Navy, and Air Force. The Army is the biggest force, having a force of more than 13 lakh. Air Force comes next, which has about 1.25 to 1.30 lakh. And Navy is the smallest unit with about less than 85 to 90,000 people. All the 3 have 3 different acts. Now the acts provide for various aspects, from the time of recruitment, enrollment, attestation, what are the service conditions to be framed, who can formulate the law. But the most important aspect pertains to discipline and procedures for making discipline. I am talking about discipline and procedure because you are all lawyers and you would be concerned with that. And that is where most of you might have heard something like court-martial, procedures for court-martial. Now, when disciplinary action is taken, it's in 2 forms. One is an administrative action, and the other is disciplinary action through trials, which are known as court-martials. Now, court-martials are of various types: general court-martial, district court-martial. I will not go into details of all these things, but the procedure is laid down in the Army Act, Navy Act, Air Force Act for conducting the court-martial. Now, one important thing which I want to tell each one of you is that a man in uniform may commit any offense. The offense may be an offense under the Indian Penal Code, The offence may be an offence under the Prevention of Corruption Act. The offence may be one under the POSCO Act also, child abuse. The police registers a case against him. And the moment the case is registered and the investigation is over and the challan is to be filed, if you see section 125 of the Army Act, it mandates that the police should take permission from the commandant under whom the man is working and give an option to the commandant either to permit the police to prosecute him in a normal criminal court, or the commandant would take a decision, no, give the case to me and I'll prosecute him through court martial. And if the commandant directs for prosecution through court martial, then the court has no other option but to give it. The only option available with the judge or the criminal court is to say that for these reasons I don't agree and make a reference to the central government, and the central government will decide who will prosecute the matter. And in 99% of the cases, the moment a commander asks for prosecution by court martial, the matter is handed over to him. Now comes the issue which all of you should take note of. If a person is prosecuted in a criminal court and convicted, the conviction is for the same offence. 302 IPC, 326, 327, 376, Section 7 of Prevention of Corruption Act, POSCO Act, and the sentence is all the same. But here, the sentence is imposed by the court martial. And the sentence are punishment for the criminal offence, that is imprisonment, along with an action for removing him from service or debarring him from service, demoting him or whatever it is. In a civil organization, he will be prosecuted criminally, and if he is working in the government or some establishment, the employer takes a decision. Here, both the decisions are taken based on the same procedure. Now, once he is punished, for example, he is punished for an offence under Section 302, and he is sentenced to life imprisonment, what is the remedy available to him? An ordinary person who is tried by a session court goes to the High Court under Section 389 CRPC. But an army person does not have that right. Right from 1950 up to 2009, when the Armed Forces Tribunal was created, the only remedy available to them was a petition under Article 226 of the Constitution. And as all of you know, Article 226 of the Constitution does not permit inquiry and interference or judicial review on factual aspect of the matter. And therefore, a man punished under the court martial is deprived of his right of appeal. And therefore, in 1982, one Major Prithpal Singh Bedi filed a petition in the Supreme Court, and the Supreme Court gave a judgment in 1982 in Prithpal Singh Bedi's case, where it was said that because you took an option for trying him by court martial, can you take away the right available to him to an appeal? He does not have a right of appeal as is available to an ordinary citizen under Section 382. Therefore, a provision for appeal should be provided for him. From 1982, the matter was pending in the parliament. It was only in 2007 that a parliamentary committee recommended, yes, there has to be a forum for appeal, and that is how a recommendation was made, as it is in many of the Western countries, to create a military tribunal to try all these things. And ultimately, based on the parliamentary committee's recommendation, the Armed Forces Tribunal Act of 2009 came into force. Now, if you see the Armed Forces Tribunal Act, you will find two sections, Section 14 and Section 15. Now, Section 14 gives a general jurisdiction to the tribunal to deal with service matters. And Section 15 is a provision which is akin to Section 389 of the CRPC, and today the Armed Forces Tribunal acts as an appellate forum under Section 389 with regard to all court martials and punishment of by the court martials, including suspension of sentence, grant of bail, interfering with the punishment, reducing the punishment, holding the trial to be illegal, vitiating the trial, and remanding it back. That is the biggest development that took place in the Indian military judicial system when the Armed Forces Tribunal Act of 2009 was created. And today, we deal with such cases.